Thanks, Ashwini. Thank you for our panelists, and I think it has been a very one-sided communication from the morning since we started the communication. So before we wind up, I just wanted to ask everyone: do you have any thoughts? Do you have any questions? Do you think that either you want to pick our brains up on that one? Do you have anything that you need to think that you should clarify, or do you think that you should stress out at this point? Anything? Yes, please.
This is regarding citizens and their attitude towards personal data. So recently I had a breach from Samvad Bank where a couple of my bank accounts were released over the worldwide net. But the thing is, the banks or the companies don't actually step up privacy procedures or their protocol because citizens don't care. And I think Tanushi spoke a little about it. And how do you help the general body of citizens understand the repercussions of actually losing data? Only a few of us seem to know. And even the banking staff is not aware of the repercussions, that someone else can use my data and even create an identity for themselves to get out of jail. It can go as far as that. And how do you, particularly representing a body, and what are your thoughts about educating citizens of those types of repercussions?
Yes, thank you for that question. Actually, that is something which is not only limited to personal data protection. Like I said earlier, citizens, we are not aware of most of the rights that we have. And especially considering what has been happening around the country for the past few months, so many people, so authorities can go ahead and do whatever they want, and people are not speaking up, not because they cannot, because they are not sure whether this is something that they can even step up to. So when it comes to the anti-money laundering and know your customer policies, which has been implemented by the banks for the past decade or so, when the compliance mechanisms actually started to work out in the banks and financial institutions, there were a lot of awareness programs which were carried out by the central bank. There were awareness sessions, and there were advertisements, there was communications which were posted on social media and so on. So this was a role that was taken up entirely by the central bank as the regulatory body of the customers of the country, as well as the regulator of the banks and financial institutions. So in my opinion, I think a lot of responsibility lies on the Data Protection Authority that will ultimately be formed in the near future as the educator of this law, because I'm not sure whether you all can remember, in my presentation I mentioned that the Data Protection Authority has so many roles. There's a supervisor role, regulator role, educator, and so on, and monitoring, all those things. So under those responsibilities is one, that is to educate the citizens of their rights. Because I remember even when it comes to usage of notes and coins, what kind of notes will not be accepted by the banks or vendors. There were certain awareness programs that were carried out by the central bank. I remember specifically that there was a poster that was given in one of the knowledge sharing sessions that I had when I was in the banking industry. So a lot of responsibility falls on the authority as the regulatory body to make the citizens aware of it. And also from the organization's perspective, there's actually quite limited work that they can do, because the majority of the responsibility for Data Protection Authority to make the citizens aware of it.
Right. Thanks, Avashik. And I think that explains a lot. And if I take the corporate names away from the question that we had, I think one of the expectations when I had initial sharing, I thought initially what was expecting the breach damage for the organization could be $80 million. Not to get there is your job, right? So I think if as MAs that we have to pay $80 million and we might go for an appeal process, it will be very less for us. Might be not be a problem. But in that process, the damage, the reputation damage that is going to be caused on the name of the organization, that's going to be long lasting. That is a place any organization does not need to be. I think this explains a lot, right? So it's not the penalty that will matter. The process of getting there is what matters to an organization, not to get there rather. So thank you very much for that question. Anything else? Any other questions? Yes, please.
Hi. So I would like a collective on this question. It's from a consumer's perspective, actually. So whether I'm downloading an application or whether I'm opening a bank account or even being recruited to an organization. So can you hear me? So the golden rule basically is the consent of the data subject. That's what you mentioned. So from a consumer's perspective, even when Mohan was speaking about privacy by design, what I see is whatever I'm using, the terms and conditions that I agree to, it only allows me to enjoy the benefits of the applications or the platforms that I'm using only if I agree to it, unfortunately. So if I disagree to it, I would not be able to enjoy the benefits of it. So in terms of that, if a data subject was to disagree to certain terms and conditions, what would be the alternative flow of operations that need to be happening from a product perspective so that still the consumer is not at a disadvantage? So it's more or less like I feel consumers are having a compelled consent to the terms and conditions as opposed to a wholehearted consent. So what are your thoughts and feedback on that?
Actually, this is not really limited to data protection aspects as far as I'm concerned, because there is a set of rules and terms and conditions which are identified in law as standard terms, standard contracts, where the organization or a company has more power and they have more bargaining power than the consumer, where the consumer is not in a position to negotiate the terms and conditions of a certain product that they're buying. So there are standard terms and conditions which are in place even when we are dealing with the service providers, not only the customers. But the good news is that I do not know if it is good news, but as far as law is concerned, where there is a standard terms and conditions, let's say the consumer actually agrees to that and goes ahead with it, then the worry that the consumer has is that you will be bound by it and that you will not get any benefit or your rights are not protected. But in a court of law, when there is a standard contract, when the standard terms and conditions are predetermined by the organization and the consumer is not having a negotiating power over the terms and conditions that they agreed upon, then the benefit of the doubt is given to the consumer, and the consumer is actually favored over that because there needs to be fairness and equality when it comes to law. So even if you agree to that, it is not clearly, I mean, even if you agree to it and the organization, if they come across and say that, oh, no, look here, the terms and conditions are defined this way, so we cannot agree to that. Still, the customer is at an advantage because the law looks at it from an equality perspective, and because the customer did not have a fair bargaining power and fair negotiating power over the standard terms and conditions, and because the customer had to accept to that in order to get the product, that will be looked at fairly by a court of law.
I'd just like to add to that.
I just want to add something there because
always, if you are acquiring a service from a, let's say Gmail or Google or whatsoever, because we are very much used to it, and we openly giving our information where they have full authority on using that, even for profiling or whatsoever, right? But we are benefiting. What they always argue is, okay, I'm providing a service, I should have a return. Basically, they are returning is profiling and all that. There was a very famous case in US related to a supermarket chain. This was way back, where based on the buying pattern, they started profiling the customers and started providing certain products and services, right? And there was this girl who has bought certain things, and they profiled that girl and said that, okay, they were pushing her certain products where you market them for the pregnant people, like, and even she didn't know that she was pregnant, right? So that's the power of data, and that's the power of profiling. And she actually went against the court because that basically beyond her personal matters, that the market actor and profiled her, right? And she won the case, even though they looked at her data and all those things. The court actually ruled on behalf of her, right? So I think what Thor said, the court will always look at on that aspect when it comes to that.
Yeah, Ashwini, anything to add?
Yes, I just wanted to add to that point that the other panelists. So, like the question that was raised, this is now widely discussed in the international scenario as well, where consent that should be free and informed. It's not really the case because we really don't have a choice. It's not free. Neither is it informed because we are not reading the terms and conditions. The suggestion that's being offered now is twofold. Number one, if you see even Twitter a few days ago came up with a more easily readable terms and conditions, because they said it's like more like now, they've made a doodle through which you'll know what are the types of data that's being used, what are the purposes, etc. So in one way, your consent is taken as something that's more informed because you're actually reading and going through for what you're consenting to. But the problem that was rightly mentioned is they may not agree to all the terms. And if they don't agree to all the terms, what do? There's no choice, right? They have to then not take that service. So then that's really not free consent. So for that, again, you can see some companies have adopted best practices where there are various options, especially those operating out of the EU, where you have accept all cookies as one option. But you also have options such as personalize your cookies. So you can actually personalize those terms and conditions for which you're agreeing to. You didn't need to agree to everything. It's no longer just agree all, or you only have to not get that service. They are not the only twin choices. So some organizations are doing better. Thank you to the efforts of legislations across the globe, but we still have a long, long way to go in terms of just how these terms and conditions are being accepted or rejected in totality.
Thanks, Ashwini. So, in the interest of time, we'll probably close for the questions, and I would hand it over back to Derek.
Thank you, Mohan. Thank you, Buddhika, and thank you, Tanushi, Ashwini as well. I'd like to humbly request you all to remain on stage. We have a token of appreciation for you all. So I'd like to invite the president of the ISACA Sri Lanka chapter to give away the tokens. Thank you, everyone. Now we have another session for you all. We'll conclude the program for today with a vote of thanks given by the Vice President, Mr. Lakmal Ambulanian. And then it's time for the networking session, and this is lunch arranged for you all. So please do go ahead, but first and foremost, I mean, first things first.
Nice, okay, thank you. Okay, thank you very much everyone for the participation today. I think it's almost like a full day when we should have done. Basically, we have to until 4:30, so 1 hour lunch, so it's a full day. So I would like to thank all the speakers and the panelists, and I would like to thank our main sponsor, Innovate. Okay, without them, actually, we wouldn't have been this successful in this event. And our corporate sponsors, LOLC Technologies, Cyberlabs, CNETCOM, and special thanks goes to PT Secretariat. We have our new CEO attended at the event, so that it's first time I think a particular CEO of PTs have been there for whole event. That appreciated. And at the same time, Hilton Residencies staff, and finally the ISACA board members and all the committee members who have made effort to make this event successful. So thank you very much again for coming today, despite all the difficulties that we have and we are going through as a country. So looking forward to continue this journey, and I believe, okay, this is a very important topic. We have to have more practical examples, practical approaches, practical knowledge in the future. So I believe we will be able to run similar events on this particular topic. But as I heard, there's some questions, of course, without looking at all the end user license agreement terms and conditions, we are just saying yes. I mean, at what day we have gone through all the terms and conditions of that agreement? We have not, right? Terms and conditions, we always take it for the granted. So let's see. I think this will be a good opportunity for us to kind of rise as a nation as well, because when the multinational corporates just trying to push whatever they want to push the privacy limits on their own, I think we can bring our own products, services in as a country. So that would be one of the ideal ways to fight against this battle. So thank you very much again for all the participants and the panelist speakers and the board. And as Nilushi said, okay, we have lunch ready for you all. So let's wind up for the day. And thank you very much again.
Stream में नया एक और नया बजा Thank you, everyone. We are winding up the session.